Good evening, everyone. I'm Kirtana KU. So, today we are actually discussing the topic maintenance, adoption, guardianship, and legitimacy under family law. We are taking this class exclusively for the UGC NET exam, which is going to conduct in December and January first week. Our classes will be exclusively structured in such a manner to crack the next exam. So we are actually covering the syllabus in the coming classes, and we will be discussing the question papers also in the coming classes. Shall we start our class? Let's first we begin with the maintenance. What is actually maintenance? So what's the purpose and concept of maintenance? First, we can discuss that. Maintenance means providing for food, clothing, residence, education, medical treatment of a dependent. It actually represents the intersection of personal and social justice and also ensuring that no individual, especially women, children, or aged persons, is left destitute. That's the main purpose of this maintenance. And also, it actually prevents destitution and vagrancy, then ensure dignity and sustenance, and also recognize maintenance as both a legal right and also a moral duty or a obligation by a particular person. That is actually a basic idea about what is maintenance. Okay, then coming on to the maintenance, what is discussed under the Hindu law. The maintenance under Hindu law is governed by the Act, Hindu Adoption and Maintenance Act of 1956. Section 18 to 28 of the Hindu Adoption and Maintenance Act exclusively deals with maintenance of persons under Hindu law, maintenance of persons who are Hindus. This is the basic act which is covered. So, as per the act, you can see in the slide, the main beneficiaries are wife, widow, daughter-in-law, children and aged parents, and dependents. Coming to the wife, the maintenance of wife is discussed under Section 18 of the Act. And as far as wife is concerned, wife is entitled to the right of maintenance during lifetime unless she is unjust or converted. That's the basic condition regarding the maintenance of wife. Then moving on to the widowed daughter-in-law. Widowed daughter-in-law, the maintenance is discussed under Section 19 of the Act, and widowed daughter-in-law is entitled to maintenance from her father-in-law if she is unable to maintain herself. That's a criteria regarding the widowed daughter-in-law. Then coming to the children and aged parents, it is discussed under section 20 of the Hindu Adoption and Maintenance Act 1956. And it is a duty of a Hindu, whether that particular person is male or female, it is a duty of Hindu to maintain legitimate or illegitimate children and also the aged parents. That is regarding the maintenance of children and aged parents under Hindu law. Then regarding the dependents, it is discussed under section 22 of the Hindu Adoption and Maintenance Act, and also certain relatives of the deceased entitled to maintenance from his estate. That is regarding the dependents. Then there is a two case laws which is we have to remain in our mind. Our as you have a basic idea about what a net exam is. In net exam we have a complete knowledge, or we have a clarity regarding every concept that we are studying, and we should study the basic concept and also the sections in it, the explanation in the section, the particular chronological order based on the sections, and also the case laws. The judgments are very crucial regarding that while the net exam is concerned, because the structure of the net exam is it is sort out in a particular in a such a manner that just studying this concept doesn't make you to crack the exam. We have to make short notes, We have to remember each citations of the case laws, the chronological order in which a case clause is shown, and also the sections, the main section and the case law which is connected to it. So it is this manner you have to prepare for the net exam to crack it. So regarding the maintenance under Hindu law, this case, the Kanchan versus Kamalendra in 1992, which I have mentioned in the slide. In this case, it is held that the wife's right to maintenance is independent of divorce. That is actually held in this case, that is Kanchan versus Kamalendra. And coming to the Vimala versus Veeraswamy in the year 1999, it is held that maintenance includes living in the same status of husband. That is held in this uh, case. There is a basic idea or basic assumption that I think law students or who know law will not have such doubt. But even though a wife can claim maintenance, that's right. But it will be based on the condition, based on the status, based on the qualification, based on the job of both the parties, both the husband and wife. If the wife is earning well and if she can maintain herself, then the husband is not entitled to or not obligated to give maintenance to wife, but he have the right to maintain his children. That's a equal right regarding a mother and a father. So that's a basic criteria regarding the maintenance under Hindu law. And regarding Hindu law, the Hindu male, or even he is a male or a female, both have equal obligation to maintain the children and aged parents. Regarding the children, even that particular children is legitimate, both till their maturity. If that particular child is legitimate or illegitimate, in any case, if the a male or the father or the mother have the obligation to maintain them till they are attaining their majority. And regarding the doctors, they have the obligation to maintain their marriage. And regarding son, it's actually the attaining of majority. So that's mainly we have discussed under maintenance under Hindu law. Then coming to a topic that is Strithan. Strithan under Hindu law. See, the word Strithan itself means the property of the woman. It is actually called the property of woman. The Strithan denotes women have the absolute right. Woman's absolute property is regarded as Strithan, and it's actually a gift received before, during, or after marriage, whether from relatives or strangers. That is actually called Strithan. There is basically difference between Strithan and dowry. Strithan is a voluntary gift of property belonging solely to a woman. But coming on to dowry is actually an illegal consideration for marriage under the Dowry Prohibition Act 1961. Dowry is actually which is given which is agreed by the bride to give it to the family of bridegroom. That is actually the property or the any valuable security. That is actually called this dowry. But Strathan is actually woman's absolute property. This Strathan is protected under 406, 405 and 406 of Indian Penal Code, that is criminal breach of trust. See, any misappropriation regarding the Sridhan, it is actually governed by section 405 and 406 of IPC. Sorry, it's 406 of IPC. And coming to the Bharatiya Nyaya Sanhita, it is as per 316 of Bharatiya Nyaya Sanhita. This any misappropriation regarding the Sridhan is governed under this section. And as you already said, it is distant from dowry. And this regarding the legal position of Sridhar, the as I already said, the absolute ownership vests in the woman, and husband or in-laws have no proprietary rights over Sridhar. That's a basic difference between the regarding the concept of Sridhan. And there is a case, that is Pratibha Rani versus Suraj Kumar in the year 1989. In this case, it was held that Sridhan is woman's exclusive property. Retention by husbands amount to criminal breach of trust. That is actually regarding the concept of Stridhan. So I hope you got a basic idea about what is Stridhan, how it distinct with or how it is differentiated from dowry. Regarding the UGC net exam, you have to identify the basic differences and the concept of Stridhan and dowry. Then we can move on to the maintenance under CRPC, that is section 125 of CRPC. As per the new law BNSS, Bharatiya Nyaya Suraksha Sanhita, it is as per section 144 where maintenance is discussed. See, maintenance under CRPC, it applies to all religion. It is irrespective of the religion. And the eligible person as per this section is wife, minor children, aged parents, whether legitimate or illegitimate. See, we are actually discussing it in the Muslim law. Regarding the Muslim law, the father have no obligation to maintain the illegitimate child. But coming on to the maintenance under CRPC under section 125 or under the new Act 144 of BNS, the father is obligated, he is entitled to maintain the illegitimate children. So it exists under section CRPC. Okay. So that's all about maintenance under CRPC. See, maintenance under CRPC, it is actually structured in such a manner to help and uplift the weaker section or the vulnerable sections in the society. That's the main aim of this maintenance under the concept of maintenance under this section. It is to prevent the vagrancy and protect the weaker section. In the case I have given in the slide, Bhagavan Dutt versus Kamala Devi in the year 1975. In this case, it is held by the Honorable Court that maintenance is independent of personal law. It is actually based on social justice. It has nothing to do with the personal laws. Personal laws have no role in this. Maintenance under Section 125 of CRPC or Section 144 of BNS, it is based on social justice, the social morality, and also to prevent vagrants and also to ensure and protect the weaker sections in the society. That's the main aim of maintenance under section 125 of CRPC. Okay. Then we can now discuss the uh, what is maintenance or what are the criteria of maintenance under Muslim law. It is actually governed by the Act. As you can see, Muslim Women Protection of Rights on Divorce Act 1986. See, as per this Act, a divorced Muslim woman is entitled to reasonable and fair provision and maintenance within or during the Iddat period. See, I hope you have a basic idea about what is Iddat period. See, Iddat period is, I just brief it what is Iddat period. Iddat period in Muslim law is a mandatory waiting period that a woman Muslim must observe after her husband's death or after the divorce from the husband. It varies it is 4 months and 10 days after the death of a husband, or 3 menstrual cycles, or 3 lunar months for non-menstruating women after a divorce. This period actually serves to confirm the paternity of the child if the woman is pregnant and allows for mourning and emotional healing. That is actually called the Iddat period. So, under section 3 of this Act, any Muslim woman who is divorced have a reasonable and fair provision of maintenance within this period. And it also includes the mahar and return of property. That is, the mahar is the basic condition during the marriage of Muslims. It is actually an obligatory thing. It actually serves as a mark of respect for woman. It's actually based on the financial security of a woman under Muslim law. And if unable to maintain herself the post-Iddat period, the responsibility of maintaining that particular woman rests upon the relatives of the woman, or the Waqf board have the responsibility to maintain such women who are divorced and who are unable to maintain herself and also after the Iddat period. Okay, there is a case that is Daniel Latifi versus Union of India in the year 2001. In this case, it is held that reasonable and fair provision must extend beyond idat. It is actually harmonized with Article 14 and 15, like protection of the gender, protection of the vulnerable section that are women. It is actually codified in such a manner to protect women. So in this case, it was held that maintenance extends beyond idat period. That is all about the maintenance of Muslim women under this under the Muslim Women Protection of Rights on Divorce Act 1986. Okay, then we can now looking on to the other topic, that is dowry. Dowry or dower. Sorry, it's not dowry, it's dower. Dower or mahar under Muslim law. See, the dower, actually the concept means the dower or mahar is a sum of money or property which a Muslim husband is obligated to pay to his wife at the time of marriage. This is a mark of respect. It is not a consideration of marriage, but is considered as a mark of respect. It is an essential part of the nikah contract under Muslim Marriage Act and not consideration of marriage but a symbol of honor and protection. So as I already said, it is actually mark of respect, not consideration, and it's the obligation of husband to give mahar or dower to the wife during the marriage, and it's actually a part of the nikah contract. Okay. Then coming to the types or forms of dower under Muslim law. First one is prompt, that can be also pronounced or also called mujal, which is payable or immediately on demand by the wife. Then coming to the deferred or muwajal, it is actually payable upon dissolution or death. So the main purpose of this dower or mahar is the financial security for wife, comparable to the strithan in Hindu law, not the dowry, the strithan in Hindu law. So the strithan and dower are very much connected, and we have you have to clarify and study and learn what's the basic difference between dower and strithan, and also identify the basic similarities between them. Okay, so there is a case called Abdul Ghadir versus Salima in the year 1886. See, in this case, it is held that dowry is not a consideration. Dowry is not a consideration but an obligation imposed by law, as I already said. So you have to identify the basic difference between this dower and sridhar. It may be confusing, so you have a clarity regarding the concept. So that's all about the maintenance. We have uh, we can now going on to the comparative perspective, comparative view on maintenance. See, the act we have discussed, the first act we have discussed is Hindu Adoption and Maintenance Act of 1956. So as per this act, the beneficiaries of maintenance are wife, children and parents. And regarding them, the duration of the maintenance is lifetime. Regarding the wife, if she is not unchanged or converted, and parents, if they are aged, they have lifetime, they are entitled to a lifetime maintenance. And regarding the children, whether they are illegitimate or legitimate, the parents have the obligation to maintain them till they are attaining their maturity. So that also mentioned in the landmark case of Kanchan versus Kamalendra that we have already discussed. And then the next law is, or next statute is CRPC section 125 or section 144 of Bharatiya Nyaya Samhita, the new act. In this case, the wife of any faith or children and parents, till their self-support, they have the right of maintenance. And the main thing we have to stress in this section is that in the case of Muslim law, they are not obligated to maintain them if they are illegitimate child. But as per section 125 of CRPC or 144 of BNS, the father or the parent have the obligation to maintain their illegitimate child under this section. So wife of any faith, any whether illegitimate or legitimate children, and also parents have the right to right to demand maintenance under this section. Okay, that's the basic and important section. Then coming on to the next statute, that is Muslim Women Act of 1986, we have already discussed. And as per this, the divorced wife have the right to a reasonable provision of maintenance even beyond the iddah period, which is held in the case Daniel Latifi versus Union of India. Sorry, I have all the missed in the case of the maintenance under CRPC section 125, the Bhagwan Dutt that we have already discussed. So this is actually a comparative view on maintenance under the Hindu Adoption and Maintenance Act and also CRPC 125 or section 144 of Guardianship and also the Muslim woman um, the Muslim Women Protection of Rights on Divorce Act 1986. So that's all about the topic maintenance in Muslim law and also Hindu law, and we have done a comparative study also. So that's all. And also you have to remember the Strathan and Dower, Strathan in Hindu law and Dower in Muslim law, and the basic differences and similarities. Okay, so that's all about maintenance. Then we can moving on to the another topic, that is adoption. As we have discussed in the maintenance also, the adoption under Hindu law is governed under Hindu Adoption and Maintenance Act of 1956. It is explained in the section 6 to 17 of the Act. Okay, the same Act. So, coming to adoption, see what we have to remain in our mind is that adoption once made is final and irrecoverable. That is a basic element of adoption. See, we cannot cancel an adoption which we have done, even if by the natural parent, even by the adopted parent, or even by the child who is adopted. Okay, that's a basic thing we have to remind in our mind. And the adoption will create a complete legal parent child relationship, and the adopted child is deemed to born in that adoptive family, and the old ties he have with his natural family are severed. That's the basic characteristics of adoption. Regarding the adoption, the natural guardian. After the adoption, the adoptive parents will become the natural guardian of the particular child. So the natural guardian will have the right to custody, right to determine the religion, right to education, right to control the movement of of that particular child. All these rights will be vested upon the natural guardian of child. Okay. Then coming to Hindu law, there are some conditions. See, the capacity to be adopted, the capacity to give adoption, and the capacity to adopt. There are some conditions regarding that. Regarding the capacity to adopt, that particular parent or who are going to, or the particular couples or the particular person who is going to adopt a child should be major, sound mind, and Hindu male or Hindu female as per the Hindu Adoption and Maintenance Act, and also the capacity to give the natural guardian who is giving his child for adoption. So, the capacity to give even the father, mother, or guardian with the guardian, if the court permission, can have the capacity to give. But regarding the characteristics of adoption, the father have to take consent from the mother to give their child for adoption. But coming to the mother, even with the consent of the father, the mother cannot give her child for adoption. But the basic one condition is that if the father is inactive, if the father has renounced the world, or if the father had destituted them, then the mother will be the natural guardian, and she can give her child for adoption. Okay, that's a basic condition. And then coming on to the case which is discussed in it, Lakshmikant Pandey versus Union of India in the year 1984. In this case, it is held by the Honorable Supreme Court that Supreme Court have laid some guidelines in this case for inter-country adoption, emphasizing the welfare of the child. See, the welfare of the child is paramount. if we are taking a child for from adoption, or if we are giving a child for adoption, whatever be the case, the particular act must be for the welfare of that particular child and for the good interest of best interest of that particular child. The ad should be for basically for the best interest and for the welfare of that particular child. That is held in Lakshmikant Pandey versus Union of India. That's a landmark case on this concept. Okay, so that's all about adoption under Hindu law. We have discussed the adoption under Hindu law. We have seen that the adopted child, even if the child is adopted, then he have severed its all ties from the natural family which he have born. And the main thing which we have to keep in our mind regarding adoption is that adoption once made will be final and it cannot be recovered. It cannot be cancelled by any of the person. If even if the child, even if the adopted parents, even if the natural parents, they can't cancel. They cannot be irrecoverable. Adoption once made is completely final. Okay, so that's all about adoption. And coming on to the adoption in Muslim law. Coming on to the adoption under Muslim law, what's a basic thing which we have to keep in our mind is that in Muslim law, there is no concept of legal adoption. That's a basic difference in Muslim law. Islam law does not recognize the legal adoption when compared to the Hindu law, but it has some alternative. It has some alternative system. The first thing is acknowledgement, otherwise called IQRAR, IQRAR. You can see in the slide. In this case, it is actually a man's statement recognizing an illegitimate child as his own. That is called acknowledgement, and it actually create a paternity but limited inheritance rights. That particular child have limited inheritance rights, but it actually creates a penalty if that particular man statement, a man stating that that particular illegitimate child is mine, then there create a paternity, but that particular child have a limited inheritance rights. That is all about the acknowledgement, or otherwise called ikrar under Muslim law. Then there is also another concept, that is kafala, Kafala. This is nothing more than the foster care system. It's actually the foster care system which is recognized under the international laws like the United Nations Convention of the Right of Child. It is actually discussed under Article 20 of this convention, and it ensures care but not legal kinship. The child have no inheritance rights, but the child have a care. Child will get a foster care. That's actually a kafala is called. So in the case of acknowledgement, there will be paternity but limited inheritance rights. That's all called acknowledgement or ikrar. Then coming to kafala, there will be the child will get, or the parent will provide a care, but there will not be any inheritance rights. That's all about adoption in Muslim law. Actually, there is no concept of, as I already said, the Muslim law not recognize this adoption compared to Hindu law. So there are we have these two alternatives, that is acknowledgement and kafala. Then moving on to the judgment that I have mentioned in the slide, that is Muhammad Al-Habad Khan versus Muhammad Ismail in the year 1888. See, in this case, it is held that acknowledgement is valid only if legitimacy is possible. In the case of acknowledgement, it is valid only if the legitimacy is possible. I have already said that acknowledgement will create a paternity. So, for creating the paternity, there should be a legitimacy. If legitimacy is possible, then it will create a paternity, and that particular child will get a care and also the paternity. But he or she have limited rights, limited inheritance rights. Okay, then that's all about the this we discussed the adoption we have discussed. So adoption under Hindu law, say actually very much recognized under Hindu law. It actually create a full legal parent-child relationship, and adoption once made is final and irrecoverable. and it cannot be cancelled by any of them like natural parent, adopted parent or child. And there are some conditions that we have already discussed: capacity to adopt, capacity to give, and capacity to be adopted. Oh, sorry, I think we have not discussed this thing, this concept, that is capacity to be adopted. See, in the case of child who is to be adopted, his or her capacity is determined on the basis of he or she must be an Hindu, and he or she is unmarried and under 50. And also the main thing is he or she should not be previously adopted. That's the main thing. And also regarding the adoption, if we are adopting a son, that particular person do not have a son, or son. He do not have a son in his lineage. That's a basic thing. And also regarding doctor, that person do not have a daughter's daughter, or daughter. There should be a lineage of doctor in his family. That's basically about the main condition. And also if if a parent, or if a person is adopting a child, that parent should have a gap of 21 years compared to the child. He or she have a 21 years of gap coming in based on the criteria regarding the age. Okay, so that's all about the adoption under Hindu law. And also it's recognized that the adoption, that concept itself, is for the welfare of the particular child. The paramount consideration will be the welfare of the child. Then we discuss the adoption in Muslim law, that we have already seen that there is no concept of legal adoption, but there exist some alternatives, that is acknowledgement ikrar, which is claiming child as one's own, and there should be a paternity, there should be a recognition of paternity, but limited inheritance rights. And coming to kafala, that the child will get a care. It's a foster care system as per the International Convention, United Nations Convention on the Rights of Child, which is mentioned under Article 20. And here the child will get care but no inheritance rights. That's mentioned in this case. So that's all about the adoption under Hindu law and Muslim law. Then we can discuss the guardianship. Moving on to the guardianship. Guardianship under, first we can discuss the guardianship under Hindu law. See, the guardianship under Hindu law is governed under Hindu Minority and Guardianship Act of 1956. And this in this, the natural guardian will have the right to custody, as I already discussed: right to custody, right to determine the religion, right to education, right to control the movement of that particular child. And we have categorized the types of guardian as per the Hindu Minority and Adoption Act, Hindu Minority and Guardianship Act. First one is natural guardian, which is discussed under Section 6 of the Act. See, father and mother is considered as the natural guardian of a child under Hindu law. And if it is the illegitimate child, then the mother will come as the first natural guardian. Other case, the father or the mother, both are considered as natural guardian of the child. Then coming on to the testamentary guardian. See, testamentary guardian is mentioned under section 9 of this particular act. See, testamentary guardian is a guardian which is appointed through the will of the parent. The parent is appointing a testamentary guardian. And regarding the testamentary guardian under Hindu law, both father and mother can appoint testamentary guardian. But if father appointed a testamentary guardian and mother survives, then that appointment will be ineffective and mother will be the natural guardian of the child. I will repeat. Regarding the testamentary guardian, if both father and mother can appoint a testamentary guardian. If father appointed a testamentary guardian and the mother survives, then that appointment will be ineffective and the mother will be the natural guardian of that particular child. And coming on to the appointment by mother, if mother appointed a testamentary guardian for the child, even if the father appointed another, the father's appointment will be ineffective and the mother's appointment will be active at that time. That's the basic difference between the appointment of testamentary guardian by the mother and the father. If the mother not appointed any guardian, then any testamentary guardian, then the father will be the ultimate natural guardian of the particular child, even if in the case of testamentary guardian. Okay, that's all about the guardianship. And then there is another category that is called de facto guardian. See, de facto guardian is uh, guardian who do not have the legal authority or who cannot dispose the property of the child. As I mentioned in the slide, no authority to alienate or transfer the property, that is mentioned under section 11 of the act. And also there is another guardian who is called court appointed guardian. I think I have missed it in the slide. Court appointed guardian is actually based on the child welfare, which I have discussed in the adoption of Hindu law. This the welfare that ultimately explained in section 13 of the act, and its case called the welfare in the case of welfare. There's a case called Geeta Hariharan versus RBI in the year 1999. In this case, the mother can be natural guardian even during father's lifetime if he is absent or incapable. If that particular father is absent or incapable or inactive, then mother will be the natural guardian of the child. That will be held in the Geeta Hariharan versus RBI. So this is about guardianship under Hindu law. And coming to guardianship under Muslim law. Under Muslim law, natural guardian will be ultimately the father. Here, there will be discrimination regarding compared to the Hindu law. This is pure, clear discrimination regarding the mothers or the woman. Here, the father will be the natural guardian. Natural guardian is called vilayat. If there is no father, then the paternal grandfather will be the natural guardian. And Vasi is called the testamentary guardian under Hindu law. It is similar with the testamentary guardian of Hindu law. Here it is called Vasi. Vasi is actually the guardian of property of the child. He is actually appointed by will. And as we seen in the Hindu law, there is de facto guardian, which is, who cannot transfer the property, who cannot have a legal right. He manages the affairs without authority, but cannot alienate the property. That's the thing regarding the de facto guardian. So that's about the de facto guardianship under Muslim law. So here we can see that mother is not considered as a natural guardian. Ultimately, the father is the natural guardian of the child. And if there is no father, then paternal grandfather will be the natural guardian. And there is a case called Imam Badi versus Mutsadi. In this case, it is held that de facto guardian cannot transfer a minor's property. That's actually mentioned in this case. Okay. So that's all about the guardianship under Hindu law and also Muslim law. Hindu law, which is more recognized and which have an equality regarding male and female, even between the mother and father. Both mother and father have the considered as natural guardian of the child. And regarding the appointment of testamentary guardian, if father appointed a testamentary guardian and mother survives, then the father's appointment will be ineffective and mother will be the natural guardian of the child. But in the case if mother appointed a mother appointed a testamentary guardian and also father appointed a testamentary guardian, then father's appointment will be ineffective and mother's appointment will be active. And if there is no appointment made by the mother, then father will be the natural guardian. Father can be considered as the natural guardian. So that's about the Hindu law. And Muslim law we have discussed. There is a basic discrimination regarding the mothers. They are not considered as the natural guardians. So that's all about the guardianship. Then we have sorry, we have mentioned the welfare principle. The welfare principle actually means the paramount consideration is a child's best interest. The welfare of the child is considered as paramount, even if in case of guardianship or even in case of adoption, what that we are doing, whether it is adoption, guardianship, regarding the property of the child, anything we have done will be based on the best interest of the particular child or for the welfare of the child. Anything curtail this cannot be considered as a valid thing, and it will be violating the welfare principle. And the welfare principle, regarding the welfare principle, it can be said that it is the paramount consideration. Child welfare is considered as a paramount consideration and is overriding all the personal law restrictions. Here there is there is no space for personal laws. It's actually based on the norms of the society or the social justice, and also for the best interest and welfare of the child. Okay. And in the case, there's a case, a landmark case, that is Roxanne Sharma versus Arun Sharma in the year 2015. In this case, it is held that the welfare of the child is paramount even under personal laws. See, we have, yes, sorry, yes, we have personal laws, but here the personal laws have no space or have no recognition. The welfare of the child is paramount, is considered as paramount. That's all about the welfare principle. Then we can moving on to the legitimacy and paternity of the child. See, the legitimacy and paternity of the child, coming to that. Here, the Hindu law, it is recognized under Section 16 of Hindu Marriage Act 1955. It is considered as the children of void or voidable marriages uh, are legitimate for all purposes except the inheritance of corpuscular property. Regarding the corpuscular property, there is some discrimination, but the children of void or voidable marriages are considered legitimate for any other purpose except of the corpuscular property. And in uh, sorry, and coming on to the Muslim law, here the legitimacy arises only from valid marriages, which is called Sahih, Sahih, which is called Sahih, or irregular, but it's called facet marriage. Here the legitimacy arises from only for valid or irregular marriages, not for void marriages. Under void marriages, under Muslim law, is categorized as balti. It is called battle. So, void marriages, regarding the child from void marriages, they are considered as illegitimate. But the child born out of valid and irregular marriages or facet marriages, they are considered as legitimate. And here also the acknowledgement which we have discussed, which is called ikrar, that creates a limited legitimacy, but as I already said, no inheritance regarding that. So that is all about the legitimacy and paternity under Hindu law and Muslim law. Hindu law, the children of void or voidable marriages considered legitimacy, legitimate. The only thing is regarding the co-personal property. But coming on to the Muslim law, here the child born out of valid and irregular, otherwise called facet marriages, is considered legitimate. But child born out of void marriages or otherwise called battle marriages, they are considered illegitimate. And also we have discussed the acknowledgement, otherwise called ikrar. Here there will be legitimacy, but this inheritance rights will be limited. So that's the basic thing. And we have evidence at section 112. It is actually considered the presumption of legitimacy is for child born during a valid marriages, and it is as per this section, it is rebuttable only by proof of non-access between the spouses. The presumption of legitimacy can be rebuttable only by the proof of non-access between the spouses. And as per the new law, it is under section 16 of the Bharatiya Sakshya Adhinayam in the year 2023. Okay. It is section 112 of Evidence Act, but the new law, it is section 116. So that's a basic thing with regarding the legitimacy and paternity under the Evidence Act. There is also a case, that is Rivan Sirappa versus Mallikarjun in the year 2011. In the case, it is held that children of void marriage is entitled to inherit the self-acquired property of parents. See, we have seen that under Hindu law, under Hindu Marriage Act 1955, the children of void or voidable marriages, they are considered legitimate, but they have, like, there is some discrimination regarding the co-personary property. But it is held in the Revan Sidappa versus Mallikarjun in the year 2011. It is held that children of void marriages are entitled to inherit self-acquired property of the parents. Coming on to the self-acquired property, they have the rights. The and children of void marriages. But the void or voidable marriages, as per the Hindu law, the regarding the co-personary property, the rights are limited, and there are some discrimination regarding that. But coming on to the self-acquired property, they have the rights. That is actually mentioned in this case, Ravan Sidappa versus Mallikarjun. Okay. We have actually discussed like many of the landmark cases we have discussed. That is, first one is Daniel Latifi versus Union of India. Okay. Uh, Here the what is discussed in which is held in 2001. Here what is discussed is the fair provision for Muslim women beyond the Idat period. That is discussed in this case, Daniel Latife versus Union of India, to harmonize the Article 14 and 15 of the Indian Constitution. Then coming on to the Lakshmikant Pandey versus Union of India in the year 1984. Here it is held that adoption and child welfare. So the regarding the adoption, the welfare of the child is considered as the paramount, and you have to look on to that. So even in the case of adoption or guardianship, what we must stress, or what we have to preserve is the welfare of the particular child and also the best interest of the child. Okay. Any act we are any act we have done, we have to be, it should be aligned with the basic interest or the welfare of the child. That's all about this case. Then Geeta Hariharan versus RBI. In this case, it is held that the mother as natural guardian. See, in the case, if the father is inactive or father have renounced the world, then the mother can be the natural guardian. That's mentioned in Geeta Hariharan versus RBI. And also the Revan Sirappa versus Mallikarjun that we discussed earlier, that is all about the legitimacy rights. That is, if regarding the self-acquired property of the parents, the children of void marriage are entitled to inherit that. That is all held in sorry, Revan Sirappa versus Mallikarjun. And the next case is Pratibha Rani versus Suraj Kumar in the year 1985. It's based on the Strathan ownership. The women have the absolute right of the property that is mentioned in the Pratibha Rani versus Suraj Kumar, that we have discussed in the detail regarding that particular case. That is, Strathan is woman's exclusive property. It is retention by husband amount to criminal breach of trust, that is under section 405 or 406 of IPC. Then I have missed one case in this slide. That is, we have discussed the Abdul Qadir versus Salima. That is in the year 1886. This nature of dower. Here Abdul Qadir versus Salima, it was held that dower is not actually obligatory, or dower is obligatory, but it is not based on the consideration. It is actually a mark of respect. It is actually considered as a symbol of respect to the respect to the Muslim woman who is a wife, and it's actually considered the financial security for that particular person. Uh, so that's, we can summarize what we have discussed so far in this section. See the concept as per the first we have discussed the maintenance. Main maintenance, we have discussed the Hindu Adoption and Maintenance Act, CRPC section 125, and also the Muslim Protection Act of 1986. And we have also discussed the case Daniel Latifi. Yeah, here the Muslim women have a reasonable provision of maintenance even after the Idat period. And in the Hindu Adoption and Maintenance Act, we have sent the maintenance who are the beneficiaries, and the CRPC, there is the actually a basic and important provision where in the Muslim law, illegitimate children cannot have the right to maintain maintenance, but CRPC actually is very visible that even the child is legitimate or illegitimate, aged parents or parents, whether whatever be, they have the right to maintain maintenance. It is as per the it is actually structure for the uplifting and protection of the weaker section and vulnerable section. Then coming on to the adoption. The Hindu law have a basic recognition of adoption. It is governed under the Hindu Adoption and Maintenance Act. But regarding the Muslim law, there is actually no legal recognition. What is mentioned is acknowledgement, otherwise called Ikrar, or the foster care system of Kafala. And we have already discussed the Lakshmikant Pandey case. The Lakshmikant Pandey versus Union of India. In this case, it is held that regarding the adoption, the welfare of the child is welfare of the child have the paramount consideration. And coming on to the guardianship, we have discussed Hindu Minority and Guardianship Act, and we have already discussed the Geeta Hariharan case where the mother is considered as the guardian. And in the case of legitimacy, we have discussed Hindu Marriage Act 1955 and also the Evidence Act of Section 112. We have already discussed the Revansidappa case where the regarding the self-acquired property, the children of poet marriage is entitled to inherit the self-acquired property. So that's all about what we have discussed. Now I look for whether you have any doubt. I will check it on the comment. I have to now check on the comment. Is anybody having any doubts regarding that? So here I have some questions for you. See, under section 5 of Hindu Marriage Act, who is entitled to maintenance? That's I have a question regarding that. Sorry, it's not under section 5, it's under section 18. As per section 18 of the Hindu Adoption and Maintenance Act, a Hindu wife is entitled to maintenance during her lifetime unless she is unchaste or she has ceases to be a Hindu by conversion. That's all about section 18 of Hindu Marriage Act. And coming to another case, that is which case upheld the maintenance beyond idat, like we have discussed is in the Daniel Latifi case, Daniel Latifi versus Union of India, and who is a natural guardian under Hindu marriage, Hindu Minority and Guardianship Act 1956. We know the natural guardian is as per the Hindu law, both father and mother are considered as natural guardians of the child. And fourth one is this Muslim law recognized legal adoption. We have already discussed Muslim law as there is a no concept of legal adoption, but there is acknowledgement, otherwise called ikrar, where there is paternity rights, but limited inheritance rights, and also the foster care, that is kafala. And section that the question number 5 is which section legitimates the children of void marriages, that we have discussed uh, in the case, and also the we have discussed the Raman Bappa versus Mallikarjun and also the evidence that we have discussed written. And that's all about the session. And I have some more questions to you. See, regarding the nature of the mahar, which we have already discussed in the Muslim law, it is actually an obligatory payment. That's the main concept here, in which we have discussed so far in this class. So it's an obligatory payment forming part of the marriage, that is contract nikah, payable by the husband to the wife as a mark of respect and not a consideration of marriage. That is basically. And the Gita Hariharan case. Here, it clarified that the mother can be natural guardian even during the father's lifetime if he is absent or unfit to that. And that's all about that case. And here the section legitimates the children of void marriages, section 16 of the Hindu Marriage Act. We have discussed it in this. Section 16 of the Hindu Marriage Act recognize legitimize the children of void marriages, and children born of void marriages are legitimate for all purpose except the inheritance of co-partnership property. But coming on to the Ravan Sirappa and Mallikarjun, the legitimacy only from valid or irregular marriages. In this case, in Ravan Sirappa versus Mallikarjun, the children of void marriage is entitled to self-acquired property of the parents. So there is a clear-cut difference between the co-partnership property and also the self-acquired property. So that's all about today's session. I hope you have a basic idea and you do not have any clarification regarding this section, we have actually discussed. So far, we have discussed the maintenance under Hindu law and Muslim law, the Svethan under Hindu law, and also the dower under Muslim law. Then we have discussed the adoption under Hindu law, whether legal adoption where welfare of the child is considered as paramount. Then also we discuss the adoption, where there is no legal concept of adoption in Muslim law. Then we have discussed the guardianship and of Muslim law and Hindu law, and also the legitimacy and paternity. And we have discussed these landmark cases. So you have to note the citations of the case and also the chronological order by aligning with the sections. That's all. That's a way in which we have to study for the net exam to crack it. So I will I hope you have a basic idea coming on to the comparative. Here when we look onto this slide, comparative on maintenance and also the summary. That's all about the class we have taken. So I hope you have no doubts regarding the same. So that's all about today class. Thank you for joining this session, and thank you. We can see with another different topic and another interesting topic in the coming